Okay, we're going to begin the civil rights section of the fifth unit. The civil rights section for the purpose of government doesn't just focus on the struggle for liberties and government protections of African Americans, but we're also going to talk about other minority groups. But the first part will focus on the struggle of civil rights for African Americans. Um, and again, remember that civil rights are those policies that protect certain groups of people from discrimination and denial of civil liberties. And I know you're probably thinking, sweet, I've been learning about the civil rights movement since I've been in third grade, and I won't really have to pay attention. But there's actually a lot of nuances and policies that the government has towards the protection of civil rights that you might not have ever heard about. So definitely pay attention. Okay, the history of slavery. Slavery in the Constitution. Okay, slavery was never a protected institution per the Constitution, but it wasn't eliminated either. Basically, at the Constitutional Convention, the issue of slavery was ignored. They were really busy fighting other battles, like how much representation we were going to have per state in Congress, and what we were going to do about regulating commerce. But slavery is mentioned in the Constitution twice. It's mentioned in the Three-Fifths Compromise, as we were going to count slaves as 3/5 of a person so we could determine population counts for southern states. And it's also mentioned in Article 1 where there is a date for ending the importation of slaves to 1808. So it is technically in the Constitution. It is not protected, nor was it eliminated. Okay, and I don't want anybody to think I'm not a huge advocate of the Confederacy at all, and I am not, even though I've never lived anywhere but the South, I am not proud of a Southern heritage. But I don't want us to ever think that the Northern states were the huge practitioners of equality that we like to think so. They were. Northern states were very willing to send escaped blacks to or back to their masters in the South as per the fugitive slave law. Um, Freed blacks did not have the right to vote or own property up north. So, this was not something that just plagued the South. Inequalities existed in southern, middle, and northern states. The westward expansion of our country, Manifest Destiny, just complicated matters. Were we going to allow these newly admitted states to have slavery? With the increase of cotton cultivation, especially in the state of Texas, there was an increase of demand for slaves. Now, this increased demand for slaves and battles over whether a state would be able to choose their fate, or for every free state, a slave state must be admitted into the Union, all it led to was more heightened tensions over slavery. And there were really three historical factors that are going to lead into the Civil War / the emancipation of slaves. Uncle Tom's Cabin. Harriet Beecher Stowe's book, Attacking the Institution of Slavery, brought international pressure on the United States, from especially England, to get rid of the peculiar institution of slavery. One of the top 6 worst Supreme Court decisions of all time, Dred Scott versus Sanford, also was one of the things, or one of the catalysts for the early struggle for African American rights. Now, Dred Scott, the decision denied citizenship to African Americans. The Supreme Court interpreted the Constitution as the fact that there was a Three-Fifths Compromise and the fact that there was a mention of ending the slave trade, that slavery was a constitutionally protected institution. And then the election of Lincoln, and if you look at the electoral map in that election, you see that there's so much de-alignment and there's such a mix of coalitions that there were so many people that did not like Lincoln, yet he won a majority of the electoral votes, so he was elected, causing the South to leave the Union. Okay, the Civil War. The Civil War is really the beginning of the acquiring rights for African Americans. Now, a lot of people look at the Emancipation Proclamation as this great document that freed the slaves, but we watched Lincoln right before Christmas, and we know the Emancipation Proclamation was only a wartime document. It only applied to freeing the slaves in the Confederate States, and once the war was over, the Emancipation Proclamation would be null and void. What we really had to pass is the 13th Amendment, and that's what the movie Lincoln is about, is that struggle of the president trying to use the bully pulpit and using log rolling in Congress to get Congress members from both sides of the aisle to agree that the 13th Amendment had to be passed before the end of the war. And the 13th Amendment, of course, ends slavery. The 14th Amendment is really the most important one. The 14th Amendment has a lot of important aspects in it, and I am going to talk extensively about the 14th Amendment. Okay. The 14th Amendment was ratified in 1868. It creates due process clause that applies to the states. And remember, it's later used as the basis for selective incorporation of rights into states. Now, the Bill of Rights was originally written to apply only to the actions of the federal government. So the 14th Amendment was the first to contain prohibitions on the actions of states. After the ratification of the 14th Amendment, the Supreme Court had to hear a case called, or a series of cases called the Slaughterhouse Cases in 1873. The Slaughterhouse Cases said that the 14th Amendment should be understood to apply only to the plight of former slaves and assured that their equal protection or equal treatment would be protected under law. As time went on, however, the amendment has been read and interpreted more broadly, and the doctrine of incorporation has come about. When the Supreme Court uses the 14th Amendment Privileges and Immunities Clause or Due Process Clause to rule that the state law or policy has violated a Bill of Rights protection, the Supreme Court has said to incorporate that protection into state law, as per their decision in Gitlow versus New York, where the Supreme Court pulled down or got low with the protection of freedom of speech. Now, total incorporation seems like it would be a little bit more simple, but we have gone with selective incorporation, applying some protections of the Bill of Rights into states' actions, but not others. Another part of the 14th Amendment is the Citizenship Clause. The Citizenship Clause clearly overturned Dred Scott, because Dred Scott, the Supreme Court said the Constitution could be interpreted to not give citizenship to slaves. So the Citizenship Clause was essential for overturning that horribly decided Supreme Court case. Again, Privileges and Immunities Clause meant that you had protection from one state to another state, regardless of your color, regardless of your state residency, your ethnicity. You couldn't be treated unequally in another state. And then the Equal Protection Clause, again, you, regardless of your race, creed, color, ethnicity, religion, are equally protected under law and from state violations as well as federal government violations. The 15th Amendment, of course, people thought, well, if you are protected with rights, then naturally states would give you the right to vote if you were a freed black man. But that didn't happen. So 2 years later, it was essential that the 15th Amendment, Universal Male Suffrage Amendment was ratified. Now, the first time we ever passed legislation in Congress that tried to prevent discrimination by private companies was in 1875. The Civil Rights Act of 1875 is often overlooked because it was ineffective. It was, again, like I said, it is the first legislation to prevent discrimination by private companies, but the problem with it was it required black people to bring up the case, and it didn't call for federal protection. And you can understand clearly, because I'm sure you are familiar with how much pressure, especially by the KKK and other hate groups, was that black people didn't feel comfortable complaining about discriminatory practices. In retaliation to um, all of the civil rights amendments, 13th, 14th, and 15th, that were passed, the southern states decided to react with Jim Crow laws. Now, Jim Crow, of course, is a minstrel show, minstrel, why can't I say that word? Minstrel, you know, the shows where people would paint their face. That's horrible. They're painting their, like, white people would paint their face black. Jim Crow was one of the characters from those shows. So even the fact that they call them Jim Crow laws was derogatory and racist. But southern states felt that Congress overextended their power by trying to pass civil rights legislation with the ratification of the three amendments and with Reconstruction policy. So the states reacted and flexed their 10th Amendment muscles, and they did what they wanted to or what they could to limit the rights of blacks. All right, the civil rights cases of 1883, the Supreme Court heard cases dealing with the Civil Rights Act of 1875, and the Supreme Court at this time said that that the Civil Rights Act wasn't necessary because the equal protection applies to state government, not states' private businesses. So, in fact, the Civil Rights Act of 1875 to prevent discrimination or segregation by private business was declared unconstitutional and not relevant. Okay. Um, why don't I wait? Hold on. Give me a second. What was it? Yeah, it's down there. It's just out of order in my notes. But Jim Crow law. The election of 1876 was a trade-off. As long as federal troops were pulled out of the South, then the southern states would start to ignore the Civil Rights Act of 1875. And that's why they instituted the Jim Crow segregation laws, is because the election of 1876, the deal was made that Southern Reconstruction would end, even though the Southern states weren't really ready for it. In that time, between the end of the Civil War and the election of 1876, that a few years, African Americans were voted into office. African Americans were allowed to vote. We had some of our first black Congress members, and because of the end of Reconstruction, all of that quickly changed as the Southern states instituted Jim Crow. And Jim Crow, of course, those are your segregation laws. You couldn't, like, you would have your color train cars, your color waiting rooms, your color water fountains and restrooms. You couldn't eat at the counter at Woolworths. Certain stores could refuse to serve you. Those kind of things. Your black codes are your voting laws, the things that states put into place to keep you from voting, like grandfather clause. If you couldn't, if your grandfather couldn't vote, you couldn't vote. Or if your grandfather couldn't vote, you had to prove that you could read per a literacy test. Or you have to pay a poll tax. And for a long time, we had all white primaries. We're the only people that could participate in selecting a candidate for a political party were white men. Plessy versus Ferguson made all of this worse by establishing the doctrine of separate but equal. So in Plessy versus Ferguson, and by the way, this is Plessy, who was like 1/16th or 1/32nd black, but mainly white, was kicked out of a first class car of a train and told to go sit in the black section of the train. And he sued, of course, and he said, you can't segregate. It's a violation of equal protection. The Supreme Court said, actually, it's equal if you have two separate facilities that are equal in accommodations, establishing the idea of de jure segregation or segregation by law. So de jure means of law segregation. So from that point on, the southern states and private companies could have institutionalized segregation.